Consumer Counterpoint, the video podcast that talks about consumer issues in the class action space, how to mitigate against those risks. My name's Christine Argentine. I'm a partner in our Chicago office at Seyfarth Shaw.
And my name's Paul Ivanek, and I'm a senior associate at Seyfarth Shaw in the Chicago office.
And today we're talking about the Illinois Biometric Information Act, also known as BIPA. Paul, you handle lots of cases in that space, have for many, many years. Why don't you tell us a little bit about how that statute started, when it was enacted, and how these cases started to develop?
Absolutely. So BIPA was enacted in 2008 following the bankruptcy of a company called Pay by Touch. At the time, Pay by Touch was one of the largest companies that allowed consumers to link a credit card to their fingerprint and then pay at kiosks or at the register using their fingerprint. Following the bankruptcy, as an asset during the bankruptcy proceedings, Pay by Touch listed a database containing biometric information, which was the thumbprints. That, of course, caused the Illinois legislature to react, and here is BIPA. The statute prohibits the capture and collection of biometric information, which can be a thumbprint, a hand scan, facial recognition, iris scan, retina scan, really any information that is, can't be changed that can identify an individual without consent, without providing notice, without having a policy in place that identifies the purpose and how it's being deleted, how it's being stored, how it's going to be disseminated, if it's going to be disseminated. It can't be sold. It can't be, all of this without consent is prohibited. And so between 2008 and around 2015, 16, we really didn't see much in BIPA litigation. It just wasn't being litigated.
And BIPA has a private right of action, is that right?
It does,
okay.
Yes, which is why it's been particularly attractive to the plaintiff's bar. And I think once, and we'll talk about some decisions that really kind of open the floodgates. So, 2015, 16, a couple cases are coming in. Really the allegations, stemmed from employment cases, biometric time clocks, and their, employees using their thumbprint to put their, to clock in and out for their shifts or for lunch. So that's really where we saw the cases start. And then, the big challenge was, is that enough for standing for an injury under Illinois law? And so in 2019, the Illinois Supreme Court weighed in on Rosenbach versus Six Flags and said, a mere technical violation of a statute is enough to have standing under Illinois law. And in that case, that was using a user using thumbprint to gain access to the park. So that's on the consumer side. But as you can imagine, it translates perfectly to the 1,000 plus biometric time clock cases that we have seen now, where just not having a publicly available policy, which is required under the statute, not providing consent and obtaining written consent from a user, that was enough to say, the mere technical violation of not having that, setting aside any actual damage, is enough to have standing under Illinois law.
Okay, and so that's where we're seeing the causes of action fall, is under whether or not there's, you said, written consent, right?
Yes.
So someone has to consent to giving over their biometric information in writing.
Yes.
And then also, is there where else do we see the causes of action under BIPA?
Yeah. So it's there's really subsections under Section 15 of BIPA. So there's 15A, B, C, D, and E. 15A requires a publicly available policy. 15B requires that written consent. And those are in large part what we're seeing. 15D sometimes with dissemination of biometric information, it just depends on what technology, how it's being used, what's being used. And so those are kind of the big claims. You always see B, D, and E alleged, a lot, especially in the time clock cases where they're alleging that the information is leaving the employer and going to the time clock company. So there's dissemination. And it's really just what we saw between 2019 and I would say up to maybe a couple years ago was, I would call them really the low-hanging fruit cases where they're absolutely, in the employment context, there is no notice, there's no policy, so there's no consent.
Okay.
It's a very hard way to argue that unless you have an exemption that you're not liable, or at least that a plaintiff doesn't have a claim. In the consumer side, there's been less BIPA claims, but we're also just seeing more creative claims out of that. For example, There was a large class action over the last few years involving facial recognition cameras used to combat against organized retail crime.
Okay.
And so that was a big Clearview AI case. And then what we're also seeing are a lot of lawsuits, a fair amount of lawsuits against companies using virtual try-on tools in the consumer context. So trying to figure out, let's say you want to try on glasses, hat, makeup from your computer, from your phone, you can't go to the store. That technology is arguably capturing some sort of facial geometry, something to figure out how do we fit all this product on your face or on your head to see whether or not you like it. And
to make it look like it's actually on your
exactly.
image.
It's using some sort of technology that
Right.
way. So yes. And so that's where we saw some cases, and we saw the courts really get split on whether or not a plaintiff can allege a claim for virtual try-on tools. And a lot of these, there were no consent. There was no
Okay.
policy or anything in place.
So let's talk about consent then in the consumer space,
Sure.
right? So because consent in the employment space, right, is probably a little bit easier, right?
Sure.
It's standard. You can have your employees sign an agreement, a written
Right, you have
confirmation.
workplace policies, handbooks. You can put
Right.
that all in there. It's very easy to get that in there, and
Right.
who's coming in and out every day.
And those employees also know you're collecting their fingerprint. That's how they're clocking in. Talk about it in terms of the consumer space, because that maybe is a little less obvious to people what's being collected or how it's being captured, and that consent is probably a little harder to capture.
Yeah, and so that's one thing that we've been working with clients to figure out, okay, what is the technology being used to do? How are we using it? So for example, on the websites, if it's virtual try-on tools, you need to start putting together before a consumer just clicks and says, yes, I want to try this on, because you can see you're prompted, oh, would you like to try this on? A lot of the technology, you just click it and you just start using it.
Right.
Well, you need to obtain this consent. You need to provide this notice and this policy that you have in place. And so there's going to be a little bit more of some clicking before you get to trying on this product virtually. And so that's going to explain why are we collecting certain information from you, how it's being stored, if it's even being stored, because this is usually a one-time use thing, so there's no use in storing it, so it's
Right.
just going to just auto-delete. But I think it's critical, and one thing that we always talk about with privacy in general is understanding what your technology is doing. And so that's always kind of the thing that we always triage with clients of like, okay, what is it doing? How long is it holding on to information? And so, transparency is key with privacy. Plaintiffs love to argue that, oh, I didn't know what this was being used for. I don't know if it could be used for anything else. And so that is always what we're trying to figure out with clients when it comes to that.
Yeah, and that's something we've talked about on other video casts that you and I have done
Yeah.
in this space related to privacy, right? That transparency is key. Telling the consumers what is happening, what the technology is doing, what's being collected, what's being used. And the first step to that is the company themselves understanding what is happening, what's being collected,
Exactly.
what's being used.
Exactly. And so, earlier I kind of mentioned, there's some exemptions under the statute, and those are things that, we've also seen invoked in the virtual try-on space too. There's a medical exemption if technology is being captured, biometric information is being captured and collected in furtherance of medical assistance or some sort of medical process.
Okay, so how is that played out with virtual try-on?
Right. So if you're trying on a hat, there's probably not much of an argument that this is for a medical purpose. But let's say you're trying on glasses. Are you trying on prescription glasses, such that you would be doing the same thing at an optometrist's office? Courts have held that in those types of situations, that is exempt from BIPA. And so we saw cases go both ways and actually make some distinctions where it was just sunglasses being sold, non-prescription, or the plaintiff said, I tried on non-prescriptive sunglasses. That was held to have a claim under BIPA. But then someone said, oh, I was trying on glasses because I wanted to see what order I was going to use with my script. Well, that's something you do in a doctor's office, and so that's furtherance of a medical procedure or process.
Okay.
And so courts have said, that's not not a claim under BIPA based on the exemptions under the statute. And there's other exemptions too. We've seen the financial institution exemption, where we've seen a lot of universities who use biometric information or captured biometric information, sometimes for testing, proctoring, of exams, in other ways. But because they are essentially a financial institution by providing student loans, they fall under this broad financial institution exemption.
So not even necessarily related to the reason for capturing the biometric information.
Exactly.
Okay.
Exactly. And so that is, so that's where we're kind of seeing, and that's what one thing when we see these biometric privacy cases come in, we start looking at, all right, what does the client do? And what are the exemptions? And so there's also a state contractor exemption. So we try to figure out what, if anything, is a client doing, or a potential client doing for a state or local unit of government, because there's an exemption there. There's several other exemptions, including on the employment context, whether or not there's a broad management rights clause under Section 301 of the Labor Management Relations Act. That therefore, if there is, then the Illinois Supreme Court and the Seventh Circuit has held that if a time clock is something that the management deems necessary to be efficient in its business, then they're allowed to use it. Then it's basically already bargained for. And so those are always things that we try to kind of look at and see where we're at. There was an amendment last year.
Yeah, let's talk about that. So the amendment was related to the per scan violation. Is that right?
Yeah, it really changed two things. The first one was the written consent in the statute. And so what it added was that an electronic written consent, a lot of onboarding in the employment context, but also we can see it in the consumer space, where when written consent really means, written consent,
right.
We're talking about, how do we get that from consumers trying on sunglasses or
right.
prescription glasses, or
especially online?
Exactly. So it included this electronic consent is considered written consent for purposes of the statute. The other part was a reaction to the decision in Counterpoint versus White Castle, which was a challenge on whether or not a claim accrues on the first time the biometric information is collected, or each and every time that someone's biometric information is captured and collected. And so the argument there that they were trying to figure out was, all right, well, if you enroll, let's say this was an employment context, if you enroll in the time clock the first time, is that the violation? Because in White Castle, that employee, the plaintiff, she started working for the company almost a decade before she brought the lawsuit, but she kept using the same clock all the way up until when she filed the lawsuit. So the argument was, well, if only the collection and only the claim accrues on the first scan, then her claim would be time barred. And the court came back and said, actually, each and every scan is a violation under BIPA. And at first blush, it kind of made this seem like, oh boy, this is going to be a huge exposure. White Castle argued, well, such an interpretation of every scan being a violation could subject us to $17 billion in exposure. And the court said, based on plain reading of the statute, perhaps, but courts in equity have the ability to bring this down. But they also, the Illinois Supreme Court at that time also said, but the Illinois legislature should probably do something to curb this themselves.
Right.
If this is truly not what they meant, they should do something. So it took some time, but last year they amended the statute to basically say that if the collection for that a collection of biometric information for one purpose is not another violation if it's being collected subsequently for the same purpose.
Okay. So someone clocking into a time clock every day, they're clocking in for this. They're using their biometric information for the same reason each time.
Exactly. Now, if you decide to implement a secure door with facial recognition, and there's two, now all of a sudden we have multiple violations. Sure. But it was really to get away from, I would say, a minority of the plaintiffs' bar who was trying to use this per scan theory. It wasn't a large majority of the plaintiffs' bar, because I think they recognized the complexity or really just the challenges that could come about on appeal if there was this per scan theory, because even the smallest of companies would have exposure of 7, 8, 9 figures, depending on how often they had their employees use their time clocks, and if the damages were $5,000 a scan.
I was going to ask. So is that's the statutory damage is $5,000 per scan? Is there some sort of reckless threshold as well?
Yes. So there's $1,000 per negligent violation, and $5,000 for every reckless and intentional violation. I mean, the courts have not really, still to this day, really come out to show what makes a negligent violation versus a reckless or intentional violation. There was one trial that to date under BIPA, and they found for reckless violations of $5,000 a piece. It was a $228 million judgment. Having sat through that trial, you can kind of see maybe how you can make some differences between your cases and that case. But there's been no real clear showing of how do you get to reckless or intentional, but it's available.
So where do you see BIPA going this year, right? Or in the next few years? What is going to be the key pieces being litigated under BIPA?
Yeah, so I think, what we're going to see being litigated is going to be, still more of the exemption stuff. And so, state contractor, a few other, underdeveloped areas of the statute, just to figure out, okay, what are the defenses? Where are they? The other part is going to be going back to the amendment, the one of basically limiting for a single violation under the statute if it's used for the same use or same purpose, whether or not that's retroactive or not, because the defense wants to make that argument that, hey, this amendment makes clear or clarifies that this is in fact a single violation per class member, such that it should be retroactive as if it was always there. The plaintiffs are arguing, well, no, this actually changes and alters, the relief that we're seeking, so it can't be retroactive. And so that's currently actually up on appeal right now. And so there's various issues on appeal. There was a recent medical exemption decision in the context of healthcare workers using biometric technologies, and whether or not that actually, I think we're going to see a challenge of whether or not that actually extends to them using time clocks in the healthcare space. And so that's where I think right now. And then, I think the other part, which is where we always try to work with clients too, is just the sufficiency of the consent forms. And so, as I kind of said earlier, the low-hanging fruit of if you don't have a policy, you don't have a consent form, it's pretty easy unless you have an exemption to proceed with a case. Now I think there's going to be more compliance, but are your policies and practices exactly what's said in your consent form? And so I think we're going to start seeing a little bit of challenge to the sufficiency of consent forms.
Yeah. Okay. Well, that all sounds really good. We'll keep everyone posted as more decisions come out, as more challenges are made, as hopefully the Supreme Court weighs in a little bit more, maybe the Illinois legislature again,
perhaps,
possibly. Yeah. But we'll keep everyone updated on all these developments.
Great. Thank you.